May I have your lordship leave to mention, my lord?
Yes.
My lord, may I mention?
Yeah.
My lord,
Please.
it's a writ appeal against a learned single judge's order. Against the same order,
Right.
my Lord Chief Justice's bench has already admitted a writ appeal, issued notice on the writ appeal on 4th of March 2025. I am another I also wish to file a writ appeal. I'm only requesting so that I can appear physically before my lords. Can your lordships list it on Tuesday the 15th? Tuesday the 15th.
All right, 15. What is it about?
It's about
What is it about?
It's about electricity rules of central rules and the state government electricity regulations. Obliged.
PIL.
Yeah, I'll appear physically.
PIL.
Not a PIL.
All right, 15th.
15th, Lord.
15th.
Obliged.
The arbitral award is in my favor, Your Lordship. However, the commercial court, by exercising its appellate jurisdiction, has reversed the arbitral award now, Your Lordship. So there's some urgency in the matter. It may be had next week, Your Lordship.
16th. 16th.
My lords, fresh matter commercial appeal, my lords. My lords, fresh matter commercial appeal. The execution is coming on 19th, my lords. Fresh matter, my lords, commercial appeal. Execution proceedings is before the trial court on 19th, my lords. Last time I moved the memo, my lord had asked the court office to list on 16th, but that memo is untraceable. Maybe had.
This is a case where the out of the vide site allotment, bid petition is allowed, and they are directed the 15 days to comply this one site allotment. That is dated 22 January 25. The case is disposed, my lordship, within 15 days of that. BD has to allot the site, but still they have not taken any action. That 3/4 of contempt, last 3/4 the matter was came before this court, my lordship. That the matter is urgent till 6th of 6th year, month, my lordship.
6th of?
Sorry, that is next month, 6th.
June.
6th they are listed, my lordship. The thing is that I myself and they both are suffering from the cancer, my lordship. You know, when we are going to sustain, so that by that time that I
No, why should we show that?
to comply.
Why you are saying? Well, everything will be fine. Don't worry. But what? Then file IA if you are wanting to prepone it. I'll file IA. File IA. Since date is already given, file IA if you want to prepone it. Yes. Yes.
My lordship, we discuss writ petition, fresh matter, my lordship, PIL. The respondent number 4 is a builder, and he was constructed a house with a violation of sanction plan, my lordship. And he is trying to sell the apartment in various persons, my lordship. There is a urgency.
25th of April. Not possible. Yes. Even this side, the matter is worth taking after vacation. Yes.
Contempt case, my lord. My lords, the complainants are not receiving salary at all. We have already moved the application for earlier not getting
After 6th of June.
urgency because they are not receiving the salary.
23rd.
My lords, land revenue matter.
Matter, my lord. Appeal under PTCL Act, my lord. Restoration sought after 50 years of purchase, my lord. I'm the respondent here, my lord. Now taking advantage of the pendency of the appeal, my lord, they are trying to blow the land, my lord. They are trying to interfere with my possession. They are trying to interfere with my possession. I have the order in my favor. The learned single judge order is in my favor. Though there is an order in my favor, my lord, they are trying to interfere with my possession, taking advantage of this appeal.
After vacation.
I have produced the photos also, my lord.
After vacation. No time now. After vacation.
They are trying to interfere.
June. Early. 4th June.
My lords, land revenue matter, my lords. Land revenue matter, my lords. It's a writ appeal. My lords, the matter was listed last week. Your lordships have ordered for notice, my lords. Now they have filed wakalat, etc., my lords. But what happened in the district court is that, my lords, the district judge, the district commissioner is now not ready to hear my objections or ready to take my objections on the record, my lords. He has issued me the notice, but is not ready to take objections on the record. I am seeking for liberty in this writ appeal, my lords, so that I can prosecute before DC.
File IA with appropriate period. File today and we'll grant permission to move. Whenever you mention, we'll permit you. Yes.
Namaste. My case number RP 590 of 2023. HV Sundaration is the name. Party in person.
What do you want?
Pardon? Mike. My lord, the case has not been cast listed so far. After 4/7/2024, it has not been.
Some date must have been given.
Pardon?
Date must have been given to your case.
Court would have given the date it is listed.
No, this is ninth time I am giving.
I will see.
Last was 8, that is 24/03.
We'll post it. We'll try to post it in this week. We'll try.
My lord, I have requested for begging your pardon. 8, 9, 10, 11, I have requested. If it is possible on 11th at 2:30, my case is very small, minor case. So I beg my lord to
It
consider.
will be posted on appropriate day. Give detail to the learned court officer, right? Yes, anything, anybody else?
Adjournments, sorry, adjournment. At serial number 35.
One second. Okay.
Week after the lordships, I have informed the other side.
35.
This is a matter, unaided employees lordships have reduced dearness allowance on par with the government employees. This is what the matter is.
My lords, appearing for respondent in this matter, my lords. My lords, we have urgency in the matter, my lords. It may be taken up before vacation, my lords. Request.
Either today will not grant time or we'll take it after vacation.
Lords, then in second week of June, my lords.
Second week of June, as requested by learned the parties, 10 over to 17th June.
Obliged.
Please,
My lords, serial number
Serial-
24, my lords.
Serial number 26, appear for the petitioner with some slight inconvenience before or before any date post vacation subject to the convenience.
Post vacation, 26,
My lords,
20, no, date, number,
Serial number 26.
26.
Listen,
So 18th June,
much.
my lords, serial number 24, my lords.
Serial number 12, my lords.
well,
Some inconvenience, my lords, 2 weeks time will be right.
as requested by learned appellants, 10 over to 24th of June.
My lords, serial number 24, my lords.
Yes,
My lord, it's a fresh contempt petition. The complainant and the respondent entered into a mediation settlement agreement in a criminal petition filed by the respondent under section 482. And in terms of the mediation agreement, the 482 came to be allowed. After which, my lord, the respondent has completely ceased communication with the complainant and has not adhered to the terms of the mediation settlement till today.
matrimonial matter.
Please, my lord, but in a 482 criminal petition, the mediation settlement was agreed on.
It is matrimonial dispute,
Please, my lord,
23rd of this month.
wait for that.
My lords, serial number 24, my lords.
Yes, Mr.
Serial number 107, my lord. I'm for the fifth respondent. Kindly have it on 15th of this month, my lord. In this case, I'm the fifth respondent. The
107.
Karnataka Slum Development Authority.
No. No time.
My lords,
Yes.
serial number 24, my lords. I appear, serial number 24.
24.
I appear for respondent number 3, my lords. The objection is ready. I'll file it during the course of the day, my lords. It may be taken up next week or any
Let it be called out.
My lords, please.
Once it is called out, we'll see whether to
Please.
grant time or not.
My lord, serial number 10, my lord.
10.
For appellant. Kindly adjourn on day after tomorrow, my lord.
It will go beyond vacation. As requested, send over to 20th June.
Please, my lord.
Lords.
Yes.
29.
29. Yes.
Pertaining to illegal construction of shops in fire exit places. We have applied through RT with regard to some documents, your lordship. It is yet to be received. Lordship may kindly have.
When it is called out, we'll see.
Please.
Serial number 27. The other person, there's some inconvenience to the
When it is called out, we'll see.
Your Lordship.
Number 70.
70.
It will take 5 months. It will be called out during second week of June.
No, when it is called out, we'll see.
Your Lordship, serial number 48 and 49, Your Lordships, for the respondents. With regards to compliance of the order, a board has to be constituted because the respondent does not have the financial power. And now that the board has been constituted, a fresh meeting is to be held on 20th of this month, Your Lordships. It will take 2 to 3 such meetings with regards to the board to decide upon how and when to comply this order, Your Lordship.
48 and 49.
48 and 49.
So what do you want?
Your Lordships may kindly have it after vacation. Your
After
Lordships.
vacation. As requested, stand over to 25th of June.
Your Lordship, serial number 76, my Lordship. 76.
Yes, Mr.
Sir, this is a PIL matter, sir. PIL matter regarding EFT Kata filed in November of last year. It didn't come for admission hearing. It's not admitted on distance. This came for hearing last week, but it came serial number 89. I requested for early hearing that date. He said, let's see. Now this has been put it for next month. Actually, people are suffering, and I'm getting a lot of calls also from affected people.
File IA. File IA for preponement. Not
Serial
by
number
oral.
7.
Yes.
76, my Lordship. The notice has been sent, but it does not come back. So kindly
Serial-
a date may be given.
Serial
76, 76, my Lord.
76. All
Yes, my
right.
Lord.
Since notice is not served and awaited, stand over to 25th of June. As requested.
Obliged, my Lord.
Yes.
Any other mentioning? Serial number 1. Purna Chandra.
Here for the respondents, I'd like to give a joint memo.
I have one submission to make before the joint memo is taken.
We've agreed on the arbitrator.
No, we have agreed on the arbitration, no doubt about it. But will it please be considered to take page 67. It's an unstamped document. Completely unstamped, and there's a reason not I'm bringing this up. Difficulty is this. If you go to the learned arbitrator,
Can I give this?
or in view of section 16, the proceedings will be terminated. Then I am the landlord, I want my possession back.
These are some-
I don't want this to become a reason. Let them not pay the stamp and come back to your lordship. My memo is there to show my bona fides.
What is 16, section 17?
Page 67 is the purported lease document. Totally unstamped, unregistered.
No. What is section? It is dismissed. Arbitration will be dismissed.
Yes, sir.
Arbitration will be dismissed.
But section 9 is filed by them. They are the tenant. I am the landlord. What had happened was, lordship may recollect, this was last week. Their allegation is that I forcibly took possession.
16.
Section 9 code directs me to hand over possession. They once again take forcible possession back from me. Anyway, my lord, your lordships asked them if they will vacate by the end of this educational term. They are now saying no.
My lord,
The
may I just
difficulty is this,
submit?
lord. If the document is completely unstamped, in view of the 7th judgment judgment, really speaking, even the arbitrator can't proceed. What I would not want, I have to show my bona fide given the indication of the arbitrator. No
Give me
difficulty
this
with that.
judgment set.
The difficulty is if thereafter, in order to delay, they don't pay the stamp, then proceedings get terminated. Then we'll have to come back to your lordship again. I don't want that. Let them show their bona fides, pay stamp and penalty, and come back. Arbitrator, my memo is there to show my bona fides. And they've also not paid some arrears. Let them pay that.
My lord, may I just make one? May I just make a submission? We have in fact both of us given a joint memo giving the name of Justice Michael Kuna. We had shared some names. This is a common name that is agreeable to both. So therefore, my first submission, even last date, my lord said, give a common consent memo of who you prefer, so that my lords can in fact immediately refer it to arbitration. On the issue of rent, because there were some arrears of rent. May I just submit? Sir. What about their memo? Yes, my lords, we have made a renewed calculation of rent. We have done a renewed calculation. According to us, if my lords may just see the last page of the calculation, the last page, the total rentals are as per us. Of course, they may have any dispute which it is up to the arbitration. According to us, total rent due till this date is about 27 lakh 50,000. What we have paid till today is 22 lakhs. So therefore, balance rent according to us is 5 lakh 50,000 till today. We are willing to give an undertaking that within 1 week, this amount will be paid, notwithstanding the arbitration. Now, my lords, my friend made an issue of the lease agreement not being registered. The latest 7-judge bench, in fact, said that even if the agreement is not stamped or there are any other technicalities, that even that has to go before the arbitrator. So therefore, my submission is, whatever disputes with regard to the rental agreement, whether it is not registered, whether it is not stamped, all those issues will be disputes before the honorable arbitrator. Even if we undertake that 5.5 lakhs after the deduction of 2 months rent, for which 2 months we were out, thereafter we got back possession by virtue of the Section 9 order, we are in possession. Let all the disputes be before the honorable arbitrator, which we have in fact luckily been able to arrive at a common name. And even if my lords want to put some timeline also, we have absolutely no difficulty. We are not trying to delay or evade. Even if my lords want to put some timeline also for expediting arbitration, we have absolutely no difficulty. Immediately it can be started. All these issues can be taken up, and my lords can record that balance 5.5 lakhs. We will. Oh, sorry. Here.
No, not that. Something else.
No. Only this and the 5 lakhs. Oh, citations. Sorry. No, citations we've not given. Even the 5.5 lakhs, which according to us is arrears till today, in 1 week we undertake to pay to them directly. So let the matter go before the. We are
ultimately the obligation to pay stamp is definitely on them. They can't brush it aside. They can't say arbitrator for anything, for the simple reason that there's a difference between a completely unstamped document and a deficiently stamped document. A completely unstamped document, until it is cured, there is no nothing to proceed forward with.
Unstamped documents are also not rendered void, and it is to be done before the arbitrator. I just want to show the research bench.
No, Mr. Nandakumar, if you both have gone to the arbitrator and this litigation would not have been filed, the present one, then in that event you would have taken a contention that this document is unregistered.
I've done that.
So do the same thing.
But all I'm submitting is let them make a statement that they make good the stand. That's all I'm saying, because I don't want this is all I'm saying. Of course, this obligations on them, and the 7-judge bench would also say that they'll have to pay it sooner or later. It's a curable defect. I'm fully conscious of it. I'm not saying otherwise.
That also is not unreasonable.
Let them make a submission that they will pay.
It will reduce the scope of disputes.
That's all I'm submitting.
No,
why is she fighting? She's paying. That's the point.
No, ultimately
they don't want to pay rent. Last time a submission was made that they're not in arrears. Today the submission is that they're 5.5 lakhs in arrears. According to us, that amount is closer to 10 lakhs. Anyway, that's a matter the arbitrator will decide. But if they're admitting to dues, they should make that good. They can't.
May I just show it is the finding of the 7-judge bench on just the conclusion bit on stamping. That also can be an issue before the arbitrator.
I'm conscious of it. I'm not saying otherwise. I'm also saying it's a curable defect. All I'm submitting is there is today no bona fides from their side. And therefore, if the proceedings are terminated on account of the fact that there is no stamped document, but even if I go to the arbitrator, here's what will happen. Initially, the question of stamp will get raised. They'll have to go pay the stamp and penalty and come back, and only then the proceedings can continue. Now, if they choose not to do it, my difficulty is then that the proceedings will have to be terminated. That is the law. And if that is so, I am the one who wants the property back. They're in no rush.
Why are they assuming I will not cure it? Why are they?
I am asking you to show your bona fides. Don't keep interrupting like this. You have not shown any bona fides till now. Last date, the statement made was everything is paid. Today, the statement is according to them 5.5 lakhs is due.
Which we are saying we will pay.
I don't want this.
According to you, what is the due? That's correct. According to you, the amounts are correct.
No, my lord, it is not. I'll just show your lordships. If your lordships are kind enough to take the statement that they tendered today, your lordship should see payments made every month in the initial.
For 2 months, no?
No, my lord, no. I leave aside the 2 months for the time being. Initially, the rent paid is 3 lakhs, not 2.5 lakhs. The agreement, my lord, understanding was it was enhanced to 3 lakhs. They have been paying at 3 lakhs. Suddenly, they now say it is only 2.5 lakhs. If your lordship sees their payments are 3 lakhs, not mine. The third column is the payments they have actually made. They've consistently been paying 3 lakhs. November, 0 payment. December, 1 lakh. The alleged interference is in end of December. So October, November, December, there was no occasion for them not to pay. So all I'm submitting is here is a person clearly, the dispute arose in end of December and in January. So therefore, there is definitely a shortfall. Then even now, April, no payment. So therefore, my lord, according to us, this number is much closer to about 10-12 lakhs. Be that as it may, my lord, that is something the arbitrator would decide. Admitted amount is 5.5. There is no reason for them not to pay that. Admittedly, stamp is not paid. There is no reason not to pay that. That's all I'm submitting. I don't want a situation where let them place some bona fides before the court. Is all I'm saying. I have no difficulty to show my bona fides. I agree to the arbitrator. No difficulty.
May I just, my lords may just see their appeal, page 85. My lords may just see their appeal at page 85. The rent itself is 2.5 lakhs. Arbitration. May I just refer for a moment, my lords, at page 85. Kindly see. Page 85. This is the schedule to the lease agreement. Kindly see, my lords, in the table, the rent schedule is 1.5 lakhs per month under the lease agreement. And the next page, page 86, is an amenities agreement. 2 agreements were signed, amenities and facilities agreement. And my lords may just see at page 90, under the amenities and facilities agreement at page 90, just for a moment, my lords, the rent is 1 lakh per month. So if we add both of these, it comes to 2.5 lakhs a month. I was paying 3 lakhs under the impression that they will pay GST under the agreement. In fact, there is a clause, my lords, under the lease agreement at page 66. At page 66, clause 4.1. Page 66 of the appeal, my lords, of the memorandum of appeal, page 66.
69.
Clause 4.1. Rent and amenities and facilities charges shall be exclusive to the applicable GST, and lessee shall be liable to bear the GST if applicable on rent and amenities and facilities charges from time to time, and make timely payments to the lessors to enable the lessors to deposit the same with the government authorities. My lords, the rent of both the property and the amenities is 2.5. I was paying 3 because the 50,000 addition was the GST 18%, which they were supposed to in fact pay up. Thereafter, the landlord didn't pay GST even till date. Now the contention taken is I'm not registered for GST, etc. Therefore, if we adjust the rent, ultimately it is 2.5 lakhs per month as per the agreement. Till now, I have paid 22 lakhs minus the 2 months deduction. 5.5 lakhs is balance. I am undertaking me even that contention, my lords. If it has to be stamped, we will have to do it. If the arbitrator so decides, even the 7
they will do it within a week.
No. If the arbitrator
That can't be. My learned friend can't say if it is not stamped. Let us see the document.
No. I'm not saying if it is not stamped. I'm not saying that.
You did say it. That's why
1 minute, sir. My lords may just see the finding of the.
No, please see the document. Page 67.
No, please, sir. I'm making my submissions. The division bench. I just want to make us one. remaining submission. Can I just, one page can I show, my lords? Page 189. Just one liberty I'm seeking. Just one page. No, I will not take more than just one page reference. 189. This is the final conclusion of the Honorable 7-judge bench in the interplay decision. Para 235, the final conclusion. Sir, 189. Yes. 189. Conclusions. 235. The conclusion reached in this judgment are summarized as follows. Agreements which are not stamped or are inadequately stamped are inadmissible in evidence under Section 35 of the Stamp Act. Such agreements are not rendered void or void ab initio or unenforceable. 235.2, non-stamping on inadequate stamping is a curable defect. 235.3, an objection as to stamping does not fall for determination under sections 8 or 11 of the Arbitration Act. The court concerned must examine whether arbitration agreement prima facie exists. Any objection in relating to stamping of the agreement falls within the ambit of the arbitral tribunal. 235.4. I'm only saying, my lords, when we have agreed to go to arbitration, arbitration clause exists, arbitration agreement is there, we have agreed to who to go to, let us go there. Ultimately, whatever
this. I'm only on page 1, para 194. Give up. Then what do I do?
And you will get your property.
I don't need your advice, please. I'm pointing out to the court. Page 175, paragraph 194. The previous paragraph in 192, they say contracts required to be in writing, stamp, the registration, etc. 194. If the tribunal and not the court which may test the requirements of a valid contract and a valid arbitration agreement are met, if the tribunal finds that these conditions are not met, it will decline to hear the dispute any further.
Yes.
Yes.
Yes. So it is.
Therefore, my submission is today on the face of it, page 67 document is not stamped. I concede the position that arbitrator has to examine the extent of the stamp, etc. Yes, all I am submitting is that let them make a submission that they will not walk back from this, so that I am not put to prejudice. That's all. Their obligation to stamp, pay stamp. Let them then make a submission.
I will not walk back from whatever the tribunal decides. Whatever the tribunal decides, I have to do.
Very good.
Yes.
I about that.
Yes.
That's all. The reason I'm making that distinction is.
Yes. No.
But yes, but the difficulty
Yes,
is
yes,
I am bound to raise it. Malad, please appreciate for a minute, Malad, my.
I'm the tenant. All these issues can be raised.
Lord, on 3 lakhs, it's for 3 years according to the deed. It will be reasonable plus 10 times penalty they'll have to pay. That is why I'm talking. Into 3, that is not for the average. Into 3 years, therefore, it will be higher. It is a slightly higher. Yes. And 10 times penalty on.
And they're two separate agreements.
That's all right. On insofar as on the lease point, I'm not on the facilities, etc. That perhaps the stamp will be lesser. I concede that position.
No, whatever is the, my lord's requirement,
let
the arbitrate, we are bound by it. The finding is that these issues must be raised before the tribunal. It is before, in the ambit of the tribunal. If the tribunal passes any, they are free to raise that objection. They can definitely raise it. We'll also have to see under the agreement what are the obligations to pay the stamping, whether we both have to pay or what.
Till the stamp is paid, the agreement can't be looked into. Be that as it may.
Two agreements.
Yes. These issues to be raised before the tribunal, my lords. That is what the 7-judge bench has held. That any time certain at 235.4, any objections relating to the stamping fall within the ambit of the tribunal. Yes. Yes. Yes.
That's all.
Yes, whatever the arbitrator decides, yes. Yes. I'm sorry, my lord.
That's all I want.
I only want to, 1 minute, sir. It decides. Yes, yes, if arbitrator decides. No, no, that is not our intention. If the arbitrator decides. Yes.
Please,
yes.
I'm so glad.
The parties to pay because
what parties? You.
No. If the I'm only saying if the arbitrator says both parties have to pay.
No.
No. Whatever if the arbitrator says no.
No, the cat is out of the bag.
No. Whatever the arbitrator decides on payment of stamp duty, we bound by it. My lords may record that. We have no difficulty. We are binding by it. We have no difficulty in that. My lords, if that is the case, if the arbitrator says it is our responsibility, we will have to pay it. If the arbitrator says both of them, ultimately whatever the arbitrator decides on payment of stamp duty, we will abide by it. My lords may record that. Our intention is not to come up with some third argument after that.
Karnataka Stamp Act requires them.
Yes.
If the agreement has a contrary clause, now my lord, my learned friend wants to try and force the liability on me. That is what my.
If it is not there, it is not there.
Please don't keep interrupting like this.
Please speak with some.
This is all I want. Now the cat is out of the bag. That's why I said total lack of bona fides. And my lord, I'm being shown right. Total lack of bona fides is proven by my.
If that is my friend's understanding, my lords have understood what I have submitted.
I don't need to understand anything. The law says so. Yes.
Then what is the worry? Exactly. Why is my friend worried?
There is a reason. I'll tell you lordships what. I may have a counterclaim. Let me not point out what it is. They are the claimant. I will be the counterclaimant. If they choose not to pay, the obligation will initially be on me and then I have to recover. I don't know what I will recover from them because they're already in arrears of rent.
They have 20 lakhs of mine
sitting don't there. Interrupting like this. This is what I'm pointing out to the court. That is why let her make a statement. She's not willing to do that.
I am willing to my lords asked me, I'm willing to state whatever are the orders of the Honorable Tribunal on stamp duty, we are willing to abide by it. That can be taken as an initial issue. Whatever the tribunal decides on payment of stamp duty, we will abide by it. Absolutely no difficulty. If the tribunal decides we have to pay, we have to pay.
But please see page 82. Obligations on them even under the agreement. If she wants to walk away from it, then I don't want arbitration. I'll work out my remedy there.
I'm sorry, my lord. That is my arrears of rent which I have.
Right.
Further amount with respect to what? I just want a clarification what my lords had in mind. No, as and when the rent is due, even after April. Yes. As I stand in my disputed. May I make one submission for my lord's consideration? Our calculation, which in fact I have reviewed, what my instructing counsel and I have reviewed, apart from 2 months, 2.5 lakhs is paid. In any case, we have to continue paying. Yes. Yes, we have to continue to pay. Which will be adjusted. We are definitely not disputing that. Which will be adjusted, definitely we don't dispute.
Stamp obligations on them, my lord, under the unstamped term. That page 82, clause 23.1, stamp obligation is on them under this unstamped term. 82, clause 23.1.
$82.
23.1, sorry, clause 23.1.
79.
I'm sorry, there's some.
Yes, 79.
I apologize.
Yes.
Clause 23.1.
My lords, whatever is the finding, whatever the arbitral tribunal decides, we are bound by it. We have given that to my lords. There's no difficulty with that. We don't intend to go back on that. Whatever the tribunal decides, we are bound by it on stamping. Let that issue be raised.
So this is a commercial appeal.
Commercial appeal, my lords.
Lodge.
Don't circumvent the GST. GST is the biggest issue. Hence, it becomes more. There are two. One, whether the arbitration clause is in this. Yes, there's a section 11. They say this is supplanted by this. But there's no arbitration clause as such.
Clause 28.23.1.
My lords, page 189, interplay, my lords.
Interplay.
The decision is at page 59. The starts at page 59. 7-judge bench decision, my lords. It's just called in re interplay between arbitration. 1 week, my lords. Yes.
Gotcha. No, but according to this termination. You actually not say substance below because according to the
Yes.
I'm grateful.
Yes, grateful.
Lodge. So good. One other request, if it could be at the Bangalore Arbitration Center.
Yes, yes, it is there. Usually it is there at the Bangalore Arbitration Center.
The arbitration we held through the
Bangalore Arbitration Center. Two weeks, my lords have mentioned 2 weeks. Future rents. By the arbitration of the tribunal.
That makes sense. That's okay. So great.
May-
So very good.
May I just make one submission? May I just make one submission? My lords asked us to pay 7.5 lakhs, which we are certainly going to do. May I only request that since this 7.5 lakhs, my lords indicated as an advance to be adjusted towards future rent, then over and above that, if we pay additional rent, it is as if we are not only paying the monthly, but we are also depositing additional. And that may not be, that would be a double liability on us. My lords may consider that.
Maybe towards any disputed areas of it.
No, towards whatever future area, future payments, future.
Clear.
To be adjusted. Grateful.
Lodge.
Grateful.
Please, madam, that's fine.
No, whatever is the adjustment, whatever is the adjustment,
But my request is
whatever is
that
the,
adjustment is towards anything in the past. Or future, whatever, as long as they're in occupation, they
whatever is the tribunal's finding, whatever is the tribunal's finding to be adjusted.
As long as they are in possession, undisputed rent of 2.5, let them continue.
No.
That's all your lordship. Yes, madam, I'm sorry. Very good, very good.
Can it be adjusted? That may be put, my lords. That the 7.5 is to be adjusted towards whatever rental dues, if any, which may be findings.
I'm very good.
My
My
only
another half an hour we could have completed the arbitration. Nothing but
my only concern is that apologies for once again submitting. Bangalore Arbitration Center.
Great. So very good.
Grateful, madam. Grateful.
Seal number 2.
I appear for the complainant matter. My lord, learned single judge was pleased to allow the review petition.
Seal number 3.
Complaint in this case.
also be permitted to serve notice on the advocate appearing before the
Number 4.
Manoj, similar matter is listed on 15th Manoj, of this month. Yes, Manoj. Yes, 15th. Manoj, may I kindly be permitted to take out hands?
15.
Yes, I may be permitted to take out hand summons as well.
Number 5. For the complaint case, my lordship, the complaint has filed his contempt petition against accused person on the part of not complied the order of the single judge of this honorable court. Page number, Connection A, page number 19, my lordship. Consequent to the restorations of the land in favor of the petitioner, the revenue and fees shall also be restored in the RTC. But in the what was passed by the single bench, my lordship, on 2nd April 2024. And the complaint has filed the representation on 9/5/2024. Till now, they have not complied the order of the single judge. This is the point number 6, page number 19. Number 6. Sir, Writ petition PL, Mr. Muralidhar. Mr. Muralidhar HM. Six.
It's coming up for the notice has not been issued.
Number 7,
Number 7.
Case
pertains to a plan sanction which has been granted by municipal authorities with respect to land, survey number 20/4 Mallards at the Koppal city. I draw the attention of this honorable court to page number 59 Mallards Annexure D. A plan sanction which has been granted for erecting a commercial complex on a particular land, measure which is denominated as survey number 20/4 Mallards. I take your attention of your lordships to the conversion order which has been granted with respect to the same land. The operative portion is at page number 42, Mallards. Annexure B. The translated copy is at page number 42. Paragraph number 6 of the said document, Mallards, categorically reads, as per government order number PWD so and so, and B, Central Government Transport Department letter dated so and so, a distance of 40 meters from the central of national highways and state highways, and distance of 25 meters from the center of district highway, and no structures shall be erected in the said open space. Is the condition which came to be imposed while granting of a conversion order. Now, my lords, categorically, when the map is seen at page number 57, it is a district highway, my lords, which is by itself measuring about 24 meters in length. And that, my lords, 25 meters which had to be left on each side of the district highway from the center of the road has not been meticulously followed, and a plan sanction has been granted. Representations came to be made by the petitioners, my lords, before the authorities, but no action till date has been taken, my lords. Plan is at page number 57.
Malad, please see paragraph 8 of the writ petition, Malad. The concerned authority itself overlooks this condition and grants the sanction plan. Paragraph 8, and it is granted on 9/11/2020. Construction must have been complete because the sanction plan, Malad, the validity is only for 1 year usually. And thereafter, Malad, on request, it is extended. Considering that this is of the year 2020.
Still, permanent structures and constructions have not been put up, my lords. But under the guise of this plan sanction, they are trying to proceed now. Against which, my lords, representations came to be made by these persons, my lords, who are petitioners in this case. They do not have any personal interest, but they are in the same vicinity of the same location, my lords. At page number 66 is the representation type of copy. No one else in the same road has been putting up such kind of constructions. 25 meters has been marginally followed by other people. Whereas only this person, my lords, under the guise of a plan sanction having been obtained from the authorities, has been trying to evade the law.
9/11/2020. My lord, it is produced as the next page 57 and 58, but I don't have the English translation.
59 is the English translation.
Not you the period also for which it is valid up to which is
No, construction is yet to commence.
yes, and not but the town municipal. Not it is the respondent. Not it is the respondents 3, 4, and 5. Not and the period is usually given, but my copy doesn't have that. Not the validity period.
Conversion translated to page number 40 minutes. Should be.
Not in case it is already constructed. I wouldn't know, my lord. We are 3 years after the sanction plan. I will.
No, my lords. It is not yet constructed. Only temporary structures have been put up. Now they are trying to make out a permanent structure there.
My lord, even for
Therefore,
that,
we have
my lord,
approached
they
this
have
court.
to have a sanction plan. That should be continued. The sanction plan, which was originally granted, my lord, that has to be renewed. And my lord, that I don't have the particulars because the sanction
My lords,
plan
all that is
be valid for a certain period.
Yes, I have provided the copy.
But that doesn't have. My lord may grant me a week's time. I'll get the information.
Now the question is that whether the marginally 25 meters from the center of the load has to be left or not. Even as per the conversion order, it is a precondition. which is granted to them. If they are leaving the 25 meters, problem is solved, my lords. It is only compliance of the regulations strictly. There was another direction in that 34675 or 2024, which came to be posted on 26/3/2025 to be taken up along with this matter by this honorable court. Whereas now that that matter also may be clubbed along with this matter. WP 34675 or 2024. Specific direction has been passed in that matter to be clubbed with this case. Your lordships, 26/3, my lords. My lords, there was no notice issued, but that was supposed to be taken up along with this matter, my lords. But it has not been posted along with it today. Yes, my lords, it may be taken up tomorrow together, my lords. Much up.
Yes, the sewage drainage and the sanitary pipelines in and around the.
Every day this one PI comes.
This is
the ideal
this is only the third PI we have filed. Why not? This is the third PL that we have filed. One is.
Oh, you remember. Very good. This is third PL.
Yes, ma'am. My lord, sewage drainage and sanitary pipelines are in and around the Chigni Lake are entering the Chigni Lake, my lord.
This is third PI filed by the same petitioner. Same petition, ideal environment as admitted by 11 petition. Defeated PILs is the file on behalf directed to produce along with paper to CA, memorandum association and the petitioner association.
Yes, at least what is we are seeking, we are not.
Yes, say.
Still number 9. Maitreyi Krishna.
In regards to the practice of manual scavenging, my lord. On the previous date, my lords had directed the respondents to file their objections, especially the BBMP. Court may also be directed to file their objections. They have not yet filed them, my lords.
My lords, with my lordship's kind permission, but there was an affidavit that was filed, my lord, to the Honorable Apex Court in a similar matter, my lord.
Appeal,
Lord, the writ petition
In fact, Supreme Court, the matters going on where I am also appearing in the matter. Honorable Supreme Court passed orders that in the 6 metropolitan cities, completely manual sewer cleaning and manual scavenging should be completely prohibited. In that, the BBMP and BWSSB filed a statement giving an affidavit. So in fact, one of our I'm also implicated in this matter. Our submission is that though they may have given that statement, now that the Supreme Court has completely prohibited it, is it being really implemented, and such prohibition is really being complied with, is the issue. My lords, one submission is that the government had filed an action taken report on 2/12/24. Government had filed an action taken report. In that action taken report, some of the things in fact are still not done. If my lords can have that action taken report. In fact, still the sewer cleaners and manual scavengers are not yet fully identified and registered. That in fact needs to be done. If,
My lords, we have filed a latest memo of compliance on behalf of the state. My lords, in the Balram Singh matter, the Honorable Supreme Court is looking into it all over the country. State, my lords, has filed affidavit of every deputy commissioner of every district certifying that there are no manual scavengers in those districts, and those affidavits are taken on record. The complaints, if any, my lords, will be pertaining to this private establishment, those people who are not manual scavengers, who will be an employee of them, whom they are making them doing this manual scavenging. For that, we are taking action. That is one, my lords. Second, there are two prayers before, my lords. One is pertaining to manual scavenging. Second is pertaining to sewage treatment plants in private areas. My lords, even for that, we have filed a memo on Saturday, my lords, wherein now we are coming up with various recommendations along with the pollution board, how these private sewage treatment plants have to be managed. Even that I have placed on record, my lords. The state has filed all the affidavits, which is before Honorable Supreme Court, and even BBMP, BWSSB have filed their affidavits, which is also made a part of this petition. And the Honorable Apex Court is monitoring it, my lords. That would be my respectful submission.
My lord, may I make one submission, my lord? One very important step that has been taken by the state in the memo that they have filed is in respect of sewage treatment plants. They have in fact conducted in their memo, which that council had referred to, they have gone to several plants and looked at the situation in those sewage treatment plants to see whether necessary steps are being taken over there. This is pursuant to a subsequent prior memo, my lord, where they had said that they will study what has happened in respect of sewage treatment plants and come up with detailed guidelines on how on what is to be done in respect of manual scavenging that has taken place in sewage treatment plants. This is because the last few incidents of death, if my lord sees, almost 4 incidents have taken place in these sewage treatment plants. So in the memo that has been filed, they have actually gone and conducted a report, conducted spot inspections in respect of some of these plants. So one of the steps that would come thereafter, my lord, would be the guidelines which they had previously referred to, which would ensure that, which would at least bring about some kind of which would provide for guidelines which are presently absent. In their memo, which they have now filed, my lords, they have produced that report of the spot inspection that they have conducted. It's in page 30, from page 33 onwards, annexed at R2.
Translation is at page 73, my lord, in the memo. Memo dated 4/4/25, my lord.
No, if the Supreme Court says that in metro cities, including Bangalore,
seized.
The manual scavengers have
to be completely stopped.
Abolished.
It has to be all manual sewer cleaning also, which includes
Then
every.
that will govern.
Of course. Now it has to govern. In fact, they have given an affidavit saying we are going to ensure that it is prohibited. Now, my lords, I have not got the latest memo that the government has filed, but my lords,
Not
even
petitioners, we have served the petitioners.
I am one of the impleaded parties. While they have given that to the Honorable Supreme Court, the actual implementation, my lords, we have to ensure that it is really being implemented. That is our only concern. It is not that an affidavit
Can you
is.
bring that judgment and the observers?
Yes, I'll file it, my lords.
Very
There are 2-3 different orders passed. I will just submit it, my lords.
Separate compiler.
Yes, I'll just submit it, my lords. Kindly keep it next week. I'll submit all the 2-3 orders of the Honorable Supreme Court.
Lord, the Supreme Court, Lord, not only in respect of the cities, my Lord, the Supreme Court has directed the Ministry of Railways, Ministry of Defence, and Ministry of Housing also, my Lord, so that there would not be any manual scavenging, my Lord. I have placed it on record in my affidavit, my Lord, page 7, para 13, my Lord. It says, my Lord, the directions are issued for us also, my Lord, insofar as Union India is concerned.
So we'll incorporate that those directions and dispose of. Everything will be governed by the Supreme Court.
Please,
Please,
my
my Lord.
lords,
Since it's
our
monitoring, my Lord,
anxiety, my lords, our anxiety, the Supreme Court is looking at it nationally. Supreme Court will not have the wherewithal to look at the minute implementation.
We'll become specific while disposing.
Yes, yes. Let these specific orders be monitored and implemented by this court. I will submit all the Supreme Court orders.
My lord, may I make one request, my lord? Writ petition 8928, which in which I appear for the petitioner. That, my lord, there are several aspects in regard to manual scavenging that we have looked into. In that regard, my lord, it might be necessary for at least the Pollution Control Board to file their statement or file their response to what we have said. BBMP has now filed, my lord, after the last date order of my lords. BBMP has now filed what they have to say. But our writ petition looks at it little bit more comprehensively. Our anxiety, which I share with my learned senior friend, is that how this is going to be implemented. In fact, my lord, because of a series of orders passed by this honorable court, several steps have been taken. But to bring it to its logical end, my lords, if the other respondents could also be directed to file their statements. So everything is on record. My lords may hear it. My lords may hear it in all of these aspects. And if detailed orders could be passed, my lord, that would go a long way in addressing this issue.
When this Kothari files or any of you file the.
Yes. My lords, we'll file it immediately. My lords may take it any date next week, my lords, 13th next Monday. If my lords can take it next week, I'll file it by then.
Either 17th or let it be on 22nd.
22nd.
Lord, I will make one submission. 9.2, my lord. It's relating to
To be
school.
listed at 2:30.
22nd, we'll file it.
So that it can be over. No further.
My lords, we don't want it to be over. We want my lords oversight, my lords.
We want to control all PILs, to be very candid, because
True.
several PILs are pending since very long.
I agree. But
without any haste or hurry, but we want to take it to a logical line. No haste or hurry.
Yes, yes.
Listen, everybody, and we are.
Lord, the Supreme Court Lord has passed an order to make a national survey with regard to the manual scavenging. There's also a direction.
Only 20 seconds.
Please.
May I make one submission, Lord? 9.2, my lord, it is not relating to that. It is relating to school, my lord. That is allegations made by the petitioner saying that the school teachers were used, the students for cleaning a snow pit, my lord. So that we have taken action. The writ petition is not maintainable, my lord. He himself has produced with the pleadings, my lord, that we have taken action. We are suspended, and two teachers were dismissed, my lord. This writ petition is not maintainable.
That they will.
Obliged.
Grateful.
Ten is urgent. Seal number 11, so writ appeal.
Here for the appellant, my lord, this writ appeal, my lord. Lord, the appellant is Mysore Sugar Company Limited, a body that has been registered under the Companies Act, my lord, but administratively controlled by the state government, my lord. My lord, agreed by the order of the learned single judge, my lord, that pertains to the determination of age of superannuation, my lord, in respect of appellant's company's employees, my lord. The short point for consideration, my lord, before your lordship is that, my lord, the age of retirement is whether it is 58 or 60, my lord. The learned single judge, relying upon the state government notification, my lord, enhancing the age of retirement from 58 to 60 years as passed in impugned order. I request your lordship to peruse page 20, which is the impugned order. The relevant portion is at page 39, my lord, the operative portion. I may be permitted to read, my lord. The petitioners are before this court since 2015 and the representation is of the year 2014. When the resolution was passed by the board in the year 2015, knowing fully well that the government of Karnataka had taken a decision to enhance the age of retirement from 58 to 60 years and the applicability to the respondent company being a government undertaking, and in the light of tripartite agreement entered, the decision of the board not to enhance the age of superannuation is a disadvantage to the employees, and it would be futile exercise if the petitioners are directed to appear before the respondent company to consider their representation when their entitlement is clear from the facts and circumstances of the case. The coordinate bench of this court under similar circumstances in so-and-so and the division bench of this court in the case of so-and-so stated by virtue of this, my lord, from 58, it was been ordered that it has to be the 60 years. This, there are two findings, my lords, of this honorable court. I mean, the learned single judge order, my lord. One is that employees of the appellant company shall be treated on par with the government servants. And hence the notification increasing the age of retirement shall be applicable to the appellant company. This is based on this finding, my lord. And this finding is contrary to the latest apex court judgment that has been rendered, my lord. This is one. And my second ground, what they have, my lord, the learned single judge has dealt is that, my lord, S.T. Ramchandra, one of the employee of workmen of the My Sugar company, my lord, his petition was allowed and his age of superannuation was increased from 58 to 60 years. I would like to differentiate even this judgment, my lord, in respect of the petition, in respect of the respondent, my lord, private respondent, who is an officer, my lord. He is an officer and he is not a workman. So on these two grounds, my lord, I would like to place my arguments, my lord, if my lords could permit, my lord. The first finding is whether the government notification is binding on the company or not is my respectful submission on that, my lord.
Which one? 6/4/20, 6/4/15?
Please, my lord.
Government notification.
Government notification is dated, my lord, is 2008, my lord. Lord, I like to place the apex court judgment on.
We'll see that. Where is that 2018 notification? 2008 notification.
Please, my lord. My lord, it is at Annexure B, my lord, page 61. So, Annexure C, page 66, my lord. And the translated copy is at page 68. Both Annexure B and C deals with the Annexure B, so translated copies at 63, my lord.
You are a government employee?
Lord, the employee under the company, it is government undertaking.
There is no automatic equation of.
Please,
no, that is not the one. My lord, there is a government circular.
Has the company, has the company adopted this circular of the government?
No, man.
Yes.
No,
yes,
no.
Because the court has said, if at all, no, you are watching. It is a public undertaking company by the government, being run by the government. That's also admitted fact by the appellants. And the employees, one of the employees who is the medical officer, was actually similarly placed, asking him to retire at the age of 58, approached the Honorable Court, and the Honorable Court had given the verdict, stating that his age, the retirement age should be enhanced to 60, and he has given the relief. And actually, this government circular extended to all the public undertaking companies also.
My lord, Annexure R11-264, where there the board resolution specifically states that we are not increasing the age, my lord. 275 is the translated copy. 264. This is dated 6/4/2015. 275 is the translated copy. The relevant portion is at, my lord, 287, my lord. 287, agenda number 20. Regarding permission for increasing the retirement age of officers of the company from 58 to 60 years.
Agenda number?
287, agenda number 20.
20.
Board resolution, 287.
Yes.
I may be permitted to read,
Yes.
Regarding permission for increasing the retirement age of officers of the company from 58 to 60 years. The above mentioned matter has been discussed. The company is registered in BIFR since it is facing financial crisis, it has been decided that in such situation, it is not possible to increase the retirement age of the officers of the company from 58 to 60 years. And it has been decided that it is unnecessary to increase the retirement age of officers from 58 to 60 years. This is what is the resolution that has been passed by the board, my lord. This is dated 6/4/2015.
That resolution is set aside.
That is why we have been aggrieved, my lord. And if my lords could peruse the latest apex court verdict, my lord.
So Lordship may kindly exhibit P, Annexure P, 149, page. Dr. S.T. Ramachandra.
And
they have allowed it to become final.
And that
not questioned it.
That I would like to differentiate, my lord, in respect of that, my lord. Kindly peruse my statement of objections, which is at page 180. In respect of S.T. Ramachandra, my lord, what happened in that case? And relevant portion is at, my lord, para 8 of my statement of 182, my lord. I may be permitted to read, my lord. The respondent herein further submits that the respondent company is having two category of workers. That is in the workmen below the class of supervisor, and the second category of workers is called as officers who are in the rank of.
Anything, Mr. What is your submission? Anything to be submitted? Anything to be submitted by you?
Yes, ma'am.
Yes.
That is the annexure P. Although he is also an officer. This court actually categorically stated that he is entitled for the benefit as per the government circular 11/8/2008, and actually given all benefits to the doctor. And if the learned single judge also had the similarly placed doctor is that of the petitioners are entitled for the same relief. That's why he has allowed the petition. Your lordship may kindly take this annexure P, that page 149. How they have allowed it to become final? When they say that they are not the government employees and they don't come under that category. They should explain it.
The answer to that, my lord.
Then your lordship may kindly see how the learned single judge of this honorable court has dealt with the matter. The relevant paragraph is that 162. The learned counsel for the respondent would assert that the observation by the division in judgment which has no binding effect and so far as the age of superannuation is concerned, there is no categorical finding in this regard. The mere observation that in so far as the pay scale are concerned, the wage board report would apply is merely an observation and cannot be pressed into service to contend that there is a finding as to the age of superannuation also being in terms of the wage board report. It is further contended that even on an outside chance of petitioner's case being allowed by this court, it would be unjust to confer benefit on the petitioner for the period which he has not rendered in service. In that he had retired from the service at 58. If his age superannuation is to be 60 and has to be provided the benefit of pay and other emoluments for the period of 2 years, it would be conferring unjust benefit on the petitioner and he would be disentitled to such a relief on the principle of no work and no pay. The learned counsel would submit that petitioner squarely and after thought the speculation of the character and therefore it ought to be dismissed summarily and cast was wrong. Probably they have not given the full extent of the judgment in that. There, the court has the petition being granted by such benefit would militate against the principle of no work and no pay. But however, the petitioner ought not to be denied the benefit of continuing of service for 2 additional years, which was unlawful and unfairly denied to the petitioner. Hence, interest of justice would be met if this is taken into account and the respondent is directed to pay all consequences as arising out of the also. That is the order passed. So you are also, so far as this man is concerned, under the order of this interim order of this county, continued and retired.
There is a rule as on today that employees are to be retired at 58.
Yeah, that is the,
Where is that?
my lord, that is not.
Now,
part of
after
the-
all this,
Yes.
It says 58 years. That is an undisputed fact.
Thing order is there.
That is an undisputed fact, my lord.
even though that is not there, 58 years is not there, it's only 60 years.
Hard learned advocate, Mr. This is serial number. Appellant, learned additional government advocate, Mr. Raghavendra.
In this.
And government advocate
Take one
also
submission,
supported
one
the
submission,
case.
my lords. One submission, my lords. Before the learned single judge, my lords, the government has admitted that 11/8/2000 notification is applicable to the company, my lords.
Respond number
Respond number 1 and 2, my lords.
The government.
Comment, my lords.
1 and 2.
Please, my lords.
Full stop. And learned advocate, learned senior advocate, Mr. So and so, the respondent, assisted by respond number 1, original petitioner, assisted by learned advocate, so and so. The challenge in this writ appeal is directed against judgment and order dated 28 July 23, whereby the writ petition of the respondent petitioner came to be allowed. Setting aside the notices dated 22/25/9/14 and resolution dated 6/4/15. Full stop. The respondent board, the appellant herein, was directed to enhance the age of the superannuation of the petitioners from how many petitioner?
Because there is one more petition.
From petitioner
Sole
concerned.
petitioner.
Petitioner concerned. There are, all are there?
There are two petitioners, but separate writ appeal is also filed.
Petitioners from 58 to 60 years, and the benefits for the extended years were directed to be afforded to the petitioners. Full stop. As per the standing order, as per the extant standing orders, fixing the date of superannuation of the employees of the appellant Mysore Sugar Company Limited, the petitioners were sought to be retired upon reaching of the age of 58 years by issuing the notices, impugned notices. Full stop. Pressing into service. Full stop. Circular dated 11/8/2008, issued by the Department of Personnel, Administrative Reforms, Government of Karnataka, the petitioners wanted learned single judge, approached the learned single judge, seeking benefit of the said circular, which contemplates the retirement age of the government employees to be 60 years as enhanced from 58 years. Full stop. A bare reading of the aforesaid circular dated 11/8/2008 goes to show that it is extended, it is applicable to the government employees for whom the age of retirement is enhanced.
But there is also one more extension. Direction of all the government undertaking and also public sector undertaking also. That is page 5, para 5. The circular. Para 5 of the order.
Where is para?
Para 5.
There is no para 5. Only 2 paragraphs.
The government of Karnataka issued notification so and so, announcing the retirement age of the government employees so and so, which came into effect so and so, and on 11/8 directed all the government undertaking and all public sector undertaking to take immediate steps to enhance the retirement age of the employees so and so.
There is
This is a public
mismatch.
undertaking.
There is a mismatch in the page numbers, my lords. When the copy served to me is also there a mismatch in the page.
Honored advocate for the original petitioner, respondent Irina sought to submit that this circular is made applicable to all the
Government
employees of the government undertaking, and that therefore the appellant company would be covered, and the employees thereof are entitled to extended age of.
No, there is circular. There is a circular also. There is a separate circular. 11/8/2008, separate circular saying that to apply to the all public undertaking sector also. That's what my learned friend want to say.
Learned additional government advocate supported the submission
Please,
of the original petition. Full stop. There is no gainsaying that the appellant company is a company registered
And a company
as a separate entity.
Company
Full stop. Prima facie, the employees of the appellant company cannot be treated at par or in the same class for any purpose unless specifically stated with the employees of the state government. They are not the state employees on prima facie consideration, since they are governed by the standing orders framed by the appellant company. The standing orders undisputedly provide that the age of superannuation of the employees of the appellant company would be 58 years. Full stop. The prima facie proposition and position of law would be that, there is no enforceable right. There is no right with any employee to seek the retirement at an age beyond what is contemplated in the rules or standing order, as the case may be. Full stop.
There is no standing order, my lord. That is
Right
governed by
to
the
continue-
third wage boards.
To continue in service beyond the prescribed age. There is no right to continue in service beyond the prescribed age of retirement unless otherwise is specifically provided. Full stop. The court is at wit's end, WATS end, as to how the state government could take a stand, which is again taken before this court. Full stop. The directions of learned single judge permitting the employees of the appellant company to continue beyond 58 years up to 60 years is prima facie unsustainable. Full stop. The appeal deserves a final examination. It is admitted. The judgment and order of learned single judge Sullivan State.
Please. Deeply obliged.
Delay is condoned. Delay order having heard learned
285 days.
parties.
285.
Order in the IA for delay condonation. Having heard learned advocate for the parties, respective parties, and having considered the averments in the accompanying affidavits, sufficient cause is made out to condone the delay. It is condoned, delay is condoned. Then the order is appealed. Yes.
Deeply obliged.
Lord, it may be posted for early because they are 68, 70
Appeal may
years
be
old.
posted for final hearing on 18th July.
Deeply obliged.
Because there is one more matter which is 89, a similar place.
May be connected, madam.
To be listed with.
Please.
be admitted.
89.
Please.
It is to be admitted.
My lord, I have to comply. Only one, we have complied of everything, my lord, and still they have raised, my lord. Maybe a week's time may be granted, my lord, and we'll comply it and we'll connect it, madam.
89. That is the
Or else it may be connected, my lord, we'll comply with the office.
other petition in the
Only one.
common order.
It's 89.
89. madam.
89. That is the WA 882 of 2024.
Learned advocate for the appellant states that the office will be completed within
Week, my lord.
within 1 week. The appeal shall be listed thereafter.
Please, please.
Immediately thereafter.
Along with this, my lord.
Along with this.
Along with 89.1.
Yes.
Please.
Along with contempt petition number 380/24.
Please.
Then continue. Order in 90.
My lord,
90,
along with that, the serial number 11,
90,
because that is arising out of the common
90,
order.
90 of time, 3 weeks time is granted to, 4 weeks time is granted to remove the officer, failing with the contempt petition shall stand dismissed without same reference. Yes.
Please.
Okay. Yes.
12 is adjourned. Seal number 13, Mr. K. N. Subbareddy.
There is a delay. Delay.
75 days.
So notice.
Yes, please.
Notice returnable on 18th June.
18th, please. Oblige.
Seal number
But
14.
the appellants are the aggrieved persons, my lord, filing this writ appeal, my lord, aggrieved by the judgment of the Linga.
There also
single-
delay.
Please, my lord.
Delay, ma'am.
Delay of 160 days. Delay.
Please, my lord.
So notice returnable on 19th of June.
Seeking for stay of that order, my lord.
Unless delay is
Please.
on down. Yes.
Seal number 15.
Appear for the
If you are appearing for
Respondent.
the appellant, my lord. Lord, yes, my lord, we had engaged the senior counsel, but I'll start, my lord. We've engaged Mr. Dhyan Chinnappa, my lord, but I'll start, my lord. Yes. Yes, my lord,
Dhyan Chinnappa is appearing.
yes, my lord, in this matter.
help
This is
us.
relating to bank guarantee matter, my
Anybody and
lord.
everybody is welcome, but
No, I'll
you
start.
can also start.
Yes, my lord, I'll start, my lord. My lord, the appellant is the public sector bank, my lord, and the borrower.
You want to wait, we are not. We are not forcing you to argue.
No, my lord, I'll start, my lord.
Yes.
Lord, the appellant is the public sector bank, my lord, Union Bank of India, and the appellant had the appellant had sanctioned certain credit facilities in favor of one entity named Alfara. And one of these credit facilities that were availed was the bank guarantee limit, my lord. And the bank guarantee, there are two bank guarantees which were issued in favor of first respondent. So, my lord, two bank guarantees were issued. One is amounting to around 2 crores, and the second is amounting to about 5 crores. Lord, in the bank guarantee, my lord, both the bank guarantees had a specific validity period. And the first bank guarantee, my lord, BG1, which has been termed by the learned single judge, that expired on 31st March 2019, my lord. My lord,
Prepared a short note, my lord, list of dates, just to a pretty court officer said.
My lord, the second bank guarantee, my lord, expired on. My lord, the first bank guarantee, in fact, it expired in September 2018, and thereafter it was renewed, my lord. And the second bank guarantee expired on 30th April 2019, my lord. My lord, as per the bank guarantees that were issued, my lords may kindly find it on page. My lord, 128, my lord. Lord, as per the bank guarantees, my lord, specifically as per clause 14 of the bank guarantees, my lord. My lord may find it at page 133, my lord. This is the first bank guarantee. My lord has found it, my lord. Page 133, clause 14, my lord. Yes, my lord.
Now, what is the jurisdiction of the ombudsman?
Ombudsman, my lord,
Is it this
strictly speaking, my lord, it may not come there
may not fall?
because ombudsman, my lord, is not a judicial or a quasi-judicial authority. It's my
About
lord,
this, about deciding the right to invoke the guarantee.
they can't, strictly speaking, my lord, they can't. At any rate, the email along with the letter, my lord, was sent to them. Attachment was, my lord, the letter was an attachment to the email.
Email about?
Saying that, my lord, we have invoked the bank. If renew it. If you don't renew it, then, my lord.
And it is not renewed. It is not
No,
renewed.
my lord, in fact, that is our
Both
contention.
guarantees are expired in 2019.
Yes, my lord, 31/3/2019.
And from then on, they have not paid the money, my lord.
And you were invoked. You were invoked. And the bank did not pay the money. Therefore, you went to an ombudsman. Then it may be a.
My lord, in this case, my lord, they had not sought for
Their whole
invocation.
contention was email is not valid communication. That, my lord, with the greatest respect, is not correct. Enough judgments of the Supreme Court, IT information.
Email regarding your invocation.
Correct.
Which reached the bank.
Correct. In time.
In time. There is no dispute.
My lord, they had not invoked the bank guarantee, my lord. In fact, they had sought for extension. Throughout, my lord, in the trail mails, what they had sought for is an extension and not invocation per se, my lord. In fact, that is our main contention. We had raised that point that it was not an invocation per se. My lord, as per clause 14 of the bank guarantee agreement, my lord, very clearly, the bank guarantee agreement mentions that any notice of request, demand, or any other communication given in connection with or required by this guarantee shall be made in writing entirely in English and may be sent by hand or post to the bank addressed as aforesaid. My lord, further
There is a condition about how to invoke the guarantee.
Yes, my lord, this was the question, my lord.
Where is that? Where is that condition?
Please come to page 139.
39.
Yes, first bank guarantee. Para 14, clause 14. Any notice by way of request, demand, or other communication given in connection with or required by this performance guarantee shall be in writing, entirely in English, may be sent by hand or post to the bank addressed as aforesaid.
Subsequently, you address the.
Better. What is it? Then, my lord, please come to, my lord, page 140. We shall be liable to paragraph, my lord, C there. Notwithstanding anything contained herein above, sorry, C, page 140, C. Notwithstanding anything contained herein above, C, we shall be liable to pay any amount under this bank guarantee or part thereof, only if we receive written claim or demand under this guarantee on or before so and so. So, my lord, written claim or demand, email also, my lord, is a written claim or demand. That's what, my lord, the Honorable Supreme Court and this Honorable Court have time and again.
Email is written.
Yes, my lord. I'll just pass on, my lord, some judgment for my lord's consideration. Page 4, sorry, Information Technology Act itself, my lord, indicates that. Sorry, page 38, my lord, 38. Section 4, my lord, at page 39, where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in electronic form and accessible so as to.
What did the ombudsman said?
Ombudsman said, I have no jurisdiction.
Order is there, ombudsman order.
And he says there is no deficiency in service.
There is no
164, my lord.
160.
Last paragraph of page 164. This is only. It is observed that the complaint is not on ground of deficiency under clause 8.1 or 8.2 of the
160.
164, my lord.
This is only the order. That's all.
That's all.
Great. Who is ombudsman? A judge is appointed? No. But nonetheless, quasi judicial authority. Yes. This has nothing to do with the.
And the judgments of other judgments also have kept, my lord, Supreme Court, where their lordships have held that email is, my lord, valid. Yes. Communication, right.
The issue, my lord, is with respect to a bank guarantee, two bank guarantees, and with respect to invocation of those bank guarantees. Bank, my lord, did not receive a valid invocation of bank guarantee by the date fixed, my lord, under the bank guarantee. And therefore, my lord, did not make payment of the sum of money that was claimed.
What is the total amount?
No, total amount comes to about 5.5 crores. No, 7.5 crores. One bank guarantee is for 2 crores 78 lakhs.
8.35.
And the second bank guarantee is for 5.5.
8.35.
8.3 crores.
8.2 crores.
8.35 crores.
Yes.
The original request, my lord, made was for an extension of the bank guarantee. The beneficiary of the bank guarantee issued an email to the bank asking for an extension of the bank guarantee.
Where is that email?
Yes, ma'am. Please see page 143.
Page
143, my lord.
143.
143.
This one,
Yes.
sorry, please see on top, my lord. What do you say? Please see 143, my lord, right on
Pen
top.
copy of the extension letter. and
Extension
also
letter and also then hard copy.
Where is that letter?
Next page, my lord. Page 146.
No, this is not obviously not that date, because on that date they say it expired on 31/3. Therefore, that is not the.
Mr. Rolla, this is for extension.
No. That's why, my lord, please look at page 146. We refer to our request letter dated 29/3 regarding extension of page 146.
This is from BG extension.
146.
Yes.
So this is a written letter followed by email.
No. Email, my lord, accompanied this. It was an attachment to the email.
No, sir. Because please see, it says expired on 31/3/2019.
Can
It is
I-
already expired. Therefore, it could never have been issued on 19th March 2019.
Today it is encashed or not?
No, it's not.
Normal.
Why?
But we didn't encash it because it was the request for encashment did not come prior to the expiry of the bank guarantee.
Now you are a bank.
Yes.
Even if there is a confusion at the initial stage. Now this letter is clear.
Which one? No?
146.
Please see the date. No?
Whatever is the date.
No.
It is after the period of a bank guarantee.
If it's
And
after
they want its revocation. Encashment.
encashment, you can't do
Why?
after the last date. There's a date fixed by which the encashment has to be done.
Subsequently, you can't.
After that you can't do.
How can it?
That is how the bank guarantee has a validity period. If the validity period is over,
So then you are bound to.
I'm bound during that period.
No.
Yes, my lord. It has to be. Please see the bank guarantee itself. Can I humbly request my lord to look at the bank guarantee at not page 130.
So if the bank guarantee expires.
Yes.
Period expires.
Yes.
It is not encased on the last date. Subsequently, you're not bound.
No. The liability is over. The liability is over. The liability, my lord, is for a time period. All bank guarantees, my lord, are for a time frame.
What will happen to that bank guarantee then?
That expires. Unless it is, which is why they make a request for extension.
Show us the law.
They can't make a request for extension.
Show us the law.
I'll place my lord, those authorities. I don't think that will be disputed. Their entire cases, we did it before. Their cases, we did it before. Our cases, you didn't do it before.
Now, this date of page 146 is what?
147, Lord, sorry.
146, my lord, please see 146.
Not
that date could
146.
never have been so because
29th March, 19th March.
19th March, it can't be. Please see the reference.
Look at my lord, page
Please,
147. This is
once
what
again, sir.
accompanied the.
Please see the reference.
31.39.
It is expired on 31/3. Therefore, it could never have been issued on 19th
My
March.
learned friend does not want to read 147.
I will
which
read, sir,
accompanied-
but let me finish.
All right, sorry, my apologies. My apologies.
Lord, this 29th March letter was received by us only on the 1st of April. That is after the. Please see what they say, my lord. And I want you lordship to see the language. We refer to the bank guarantee issued by you in our favor for 2 crores 78 lakhs on behalf of Alfara projects. This bank guarantee is expiring on 31/3/2019. Kindly arrange to renew the same and send us the renewal letter. Then, in the event if the BG is not renewed, we hereby invoke the BG and we request you to kindly transfer the amount to below mentioned account. In case the BG is renewed before the date of expiry, request you to kindly send the original renewed BG to us.
This is renewed. Next slide. Both contradictory. Now, what you are writing here? Firstly, you said that the bank guarantee is expiring on 31/3/2019.
Arrange to renew the same.
Arrange to renew the same. And send us the renewal letter.
Correct.
In the event the BG is not renewed,
We hereby invoke the bank guarantee. That's how, my lord.
Inconsistent.
No, my lord. I'll tell you, lordship, why. Normally, my lord, we must invoke the bank guarantee within a particular period. We, my lord, ask for extension. They have been extending it all along. We said, if you do not extend it, then treat this as invocation. If they invoke, my lord, if they extend it, then, my lord, it's not invocation. This is a normal format, which is, my lord, accepted by banks and, my lord, accepted by the courts also. If necessary, my lord, I'll leave, my lord.
Not extended automatic invocation.
Correct, because my statement is, in the event if BG is not renewed, we hereby invoke the BG and request you to kindly transfer the amount to the below mentioned account.
So it is in this context of your argument that learned single judge says that it is
Yes.
rightly in.
Correct.
In view of this.
That's right.
There is
And
a
this, my
denial.
lord, accompanied the, this was an annexure to the email dated, my lord, at page 143, not 146, but 147 is the attachment.
There is a dispute, my lord, because the letter was not received.
But we fail to understand why, as a bank, you should refuse.
My lord, we refused it on the simple reason. Please see the reason, Lord, 143. When this one.
What do you gain by refusing?
My lord, no, nothing, my lord. As a matter of fact, nothing. We don't gain anything. We don't gain anything by refusing. The obligation, Lord, has, in my respectful submission, Supreme Court says, at least my understanding, my lord, is Supreme Court says that the invocation has to be strictly in accordance with the bank guarantee. If the bank guarantee requires invocation in a particular form, it has to be done in that form only. And that's what it says. I'm practically paraphrasing. If it is not done, a bank is legitimately entitled to refuse invocation and say, because here, my lord, they specifically say, ask for extension. Yes. Yes. Whom, Lord? Lord, in effect, Lord, the consequence of not invoking the bank guarantee in terms of the bank guarantee is there is no valid invocation. If there's no valid invocation, then there's no obligation to make payment. No, that is true. That letter, my Lord, was received by us on the 1st of April. May I then place one or two authorities, my Lord? I'll get authorities with respect to validity period itself. With respect to validity period, I'll place some authorities. I have authorities, my Lord, to say it should be invoked exactly in terms of the bank guarantee. Yes, my Lord. A guarantee goes. Yes, my Lord. No, it is only a, Lord, the, yes, correct. Yes, it can't be. Yes, I'll place those authorities before me. Both on validity period, my Lord, and terms. I beg your pardon, my Lord? Lord, the email which is sent is said to be sent on 29/3/2019. My Lord, 29/3, one email is received, but the hard copy of that document, my Lord. No, my Lord. In my respectful submission, it is not an invocation in order, even otherwise. There are two things. One is receipt. The second is whether it is a valid invocation in terms of the bank guarantee. Lord, valid invocation, Lord, requires necessarily, if your Lordships can take the bank guarantee for a minute. Yes, Lord. And there's a good reason for it, Lord. Please see page 133. 133, my Lord. This is one of the bank guarantees. This is the first bank guarantee for 2 crore 78 lakhs. Can I request, my Lord, to kindly come to page 133, my Lord? This is the advance payment guarantee. Yes, that was extended. It was extended to 31st of March. 31st of March. Yes. We are bound to. If, my Lord, if it is done in accordance with clause 14, page 133. Any notice by way of request, demand, or other communication given in connection with or required by this guarantee shall be made in writing entirely in the English language, may be sent by hand or post to the bank addressed as aforesaid. Now, the argument is anything that is done in terms of a letter, my Lord, can also be done by email, is what they are saying. But my humble submission, my Lord, is if a party contract requires it to be done in a particular way, it has to be done in that way. No, my Lord. Information Technology Act, my Lord, recognizes. No, that is the difficulty, my Lord, whether that is an invocation at all. Because the first request is for extension. I'll place some authorities before my Lord. I know, my Lord, I can see that. I'll try to persuade, my Lord. There are 2-3 things in this order, of course. One is, of course, the principle. Then, my Lord, the learned single judge says that we did it dishonestly, and therefore, yes, my Lord. True, my lord. That I can't dispute. No, my lord. Correct. Yes. No, but the point really, my lord, is this. If it's a little bit of hair splitting, my lord. Little bit of hair splitting. I do admit it's a little bit of hair splitting, but I think that hair splitting may work, my lord, in this context.
Like me, my lord.
Next week, Lord Smith, I'll place those authorities. Yes, no, I understand. I'll.
Not only that, email, my lord, accompanied that letter also, because no, my lord, I'll tell your lordships. Letter says, if either renew it, if you don't renew it, then my lord, this is treated as invocation. Reason is this: they have, my lord, gone on renewing it, my lord, time and again. Last date, every time, my lord, we write to them like this: either renew it, or if you don't renew it, then treat this as invocation.
But please see the email, Lord. Email simply says extend it. That's all. Nothing more.
No.
Please see 144. Page 144, my lord.
Accompanied.
No, that is the issue. The letter was only sent to us on 1/4. Please see the subject of the email, my lord, at 143. Please see the subject at 143, my lord. Doesn't show any attachment here. Subject is renewal of BG dated 27/2016, expiring 31/3/2019.
And
subject is not invocation. And please see the next page.
We are enclosing the
BG extension request, it says.
For expiring so and so. Hard copy is being sent, by post
Oh,
post
that's
also.
what I'm
That
saying.
means it accompanied, my lord, that letter accompanied as an annexure to this. Let them show that they have not received that annexure at all. They have not stated that anywhere.
No, in our reply we've said so. Our reply immediately is we can't renew it at your request.
Anyway.
Receive
ಆಗಿದೆ ಕೇಳಿದೆ.
No reason. Only one sentence, that's all there is. Yes, I'll place all those judgments before me. Lordship, ma'am, next week. 22nd. Great.
22nd.
What I think my lord, Mr. Holla would prefer 23rd.
23rd, my lord, if it's not inconvenient to my lords, my lord.
Great.
First you move those contempt automatically ಹೋಗುತ್ತಲ್ಲ. Just keep it like that.
Contempt.
Please.
Contempt.
ಇಲ್ಲ ಇಲ್ಲ contempt ಇದೆ. It's all there. Please, please.
Number 6. Number 16. Yes, sir. Stay back, Ali. Yes. 17. Number 18. Simmer.
take emergent notice. Yes.
Your Lordship, we have filed the record for respondent. Yes, my Lord. Respond.
18 days delay. Yes, please. I'll serve copies on him.
Your Lordship, kindly grant some time to file the objections to IML.
Please. Please, ma'am.
The arbitration matter, my lord. Lordships had heard us for some time last time. We got to continue today.
Then respondent number 1 also.
We'll start, my lord. We'll start. I mean, I'll start if
Respondent number 1, Your Honor. Mr. Senior Counsel, Mr. Giridhar is not in station here.
limitation. There are 4 points, my lord, which I have, which in my humble submission will, any of the grounds will result in the order going. The first, my lord, is limitation, which is on the face of it barred.
Next week, could I request?
Next week.
Next week, no, 15th.
Number 22. PA, Purnimahati.
I'm appearing for the petitioner in this matter. My lord, this matter pertains to the reliefs we're seeking groundwater authorities with respect to furnishing information on the usage of groundwater and potable water in Karnataka. My lords, on the last occasion, we had sought for certain directions for the state to declare information on the usage of groundwater, my lords, and there's already an order of this honorable court in the year of 2024, my lords. My lords, learned senior counsel wishes to argue this matter in detail. A date may be fixed next week, my lords. We'll.
My lord, my pleadings are complete. My lord, statement is filed. Affidavit is also filed.
My lords, our humble submission is that the affidavit.
My lord, there's no cause of action. This is purely academic, my lord.
If my lords may.
My
take
lord,
the
may have
direction.
this after vacation.
My lords, if your lordships may. If I may direct your lordships to the. If my lords may take the order of the Honorable Court on 29/8/2023, there is a detailed order which has been passed. With respect to the cause, my lords. They were asked to furnish certain affidavits also. My lords, our humble submission is that the affidavit they have placed on record on 4/10/2023 is insufficient.
My lord, they're seeking for a general observation, my lord. If my lord were to see the press, conduct periodical inspections regarding illegal extraction of groundwater either through pipelines, considering that Bangalore is developing so fast, my lord.
My lords, in this regard.
My lord, at least, my lord, one instance from which, my lord, they could have developed the PIL. Yes.
My lord,
No, my lord, this is a general, my lord may have this after, my lord may have this after vacation
my
because
lords,
they're
the date
seeking
may be
for.
fixed next week, my lords. We are seeking for certain directions.
So suppose some virus of the act is
My lord, there also, my lord, post. No. Yes.
My lords, the date may be fixed. Please, ma'am. Much obliged.
My lord, in this I'm
23.
filing order passed by the Conservator of Forest, my lord, under section 64A3 of the Karnataka Forest Act. My lord, wherein, my lord, the response of forest, and we have passed an order, my lord, directing.
My lord, the order was passed on the first of to us as yet. You're not aware of what the order that has been passed.
Petitioner by the 3.2 acres has been encroached.
Lord, kindly permit me, my lord.
For reserve forest.
I'm appearing for the petitioner, my lord. Due to my ill health, my lord, I could not attend the court personally. Kindly permit me to appear online. But let me, I'll take the copy from my lord, the learned government advocate, and make my submissions on the next stage.
but is complete.
Immediate position of the forest land, directly responds 3 to 4 to remove the concrete road illegally laid. That the revenue department has to file application in state regarding that. Forest land.
private response number 11 on the forest land. It was the case that the said private respondent purchased 37 acres of land in the year 1996, which was survey number 26 at Vaddara Halli village, Tumkur Taluka. It was the case that the land abutted ABUTTED, the border of reserved forest of Devara, what is that?
Devarayana Durga.
Devarayana Durga village, Uri Digre Hobli, Tumkur Taluka. It was the further case that neither Phodi or handbust was undertaken and identification of the borders was not obtained before constructing the building. The building constructed was a two-storied school building and staff quarters.
Residence of the 11th respondent staff quarters and another building on the encroached land. Residence of the 11th respondent staff quarters and another building on the encroached land she has constructed.
It was the allegation that respondent 11 encroached the said part by constructing another building.
And her staff quarters, her residence, and another building.
All. On the above paragraph, basic premise of the facts, the prayer was made. Where is the prayer? To direct the respondent 1 to 9 authorities to take immediate possession of the said land, which was alleged to be encroached by the private respondent, and demolish all the buildings constructed thereon. Full stop. Today, when the petition came up for consideration, learned additional government advocate produced on record memo dated 7/4/25, along with which she produced an order dated, which is the date?
Both, my lord,
5th of April 2025, passed by the
conservator
Appellate
of,
Authority and Conservator of Forest, Hassan Circle, Hassan. Is it Hassan?
Yes, my lord.
Hassan Circle, Hassan. Full stop. Who was the appellant? You are the appellant?
I was the appellant, my lord. Respondent number 11.
You can't be the appellant.
Lord, the order was passed against me by the ACF, my lord. I challenged this order before the CCF.
Who was the complainant? You are the complainant?
No.
In that proceeding?
The range
Yes,
forest.
my lord. Initially, the petitioners were the complainants.
My lord, the range forest officer.
Order is passed.
RF was the complainant, my lord. Range forest officer was the complainant. Based on that, the ACF passed an order, my lord. And I challenged that order.
Now you have argued, you have submitted, you have considered. Now, any interruption in the dictation of the order will not be told.
Sorry, my lord.
Please take your seat.
I'm sorry, my lord.
Yes.
The clarification.
So what did you write? Full stop. In appeal number Hassan in appeal number 18 of 2023-24, the said was the proceedings initiated upon complaint filed by the present petitioner. Full stop. The appellate authority confirmed the order of the assistant conservator forest, having found that the allegation of encroachment and the illegal construction on the forest land were correct. Full stop. Based on the finding of fact recorded, the order is passed by the appellate authority to direct demolition of the school building in question. Full stop. The appellate authority also appears to have considered the sketch of the place to reach the finding of fact. Full stop. In view of the above, the present public interest petition does not survive, as the substantial part of the prayer stands granted. Full stop. It was sought to be submitted by learned advocate for the petitioner paragraph that there is also a prayer is also advanced about the construction of road inside the forest land.
No, in the adjoining Gomala land. adjoining Gomala.
Adjoining Gomala land, full stop. This could be viewed as only an incidental relief for which it will be open for the petitioner to approach the competent authority, and the competent authority, if such representation is made, shall look into the same in accordance with law and on its merits. Full stop. As per the order, learned advocate paragraph, Mr. So-and-so, private respondent, submitted that the order is passed by the appellate authority against him, as he is the alleged encroacher. Full stop. It is clarified that the disposal of this public interest petition shall not preclude the respondent number
11.
to institute independent challenge to the aforesaid order in appeal.
Much obliged, my
For
lord.
to be considered in accordance with law and on its
Much
merits.
obliged.
One submission. I had already uploaded the revenue authorities. I had submitted representation regarding the illegal roads. They have not replied or considered it. That's one.
All proceedings relating to the forest land and the encroachment therein, which may have been instituted by any other party, shall continue to be taken to its logical end in accordance with law. And this order shall not influence the said proceedings. Next. So Gomal land is granted for lease.
This is grant was challenged earlier by filing a PIL here that was dismissed. Now after 6 years again he has come. We are filing objections, my lord, producing that order copy.
Filed objection.
Today we are.
Learned advocate, Mr. Mr. Patil, sorry, files statement of objections, which is taken on record. Paragraph.
Please.
None is present for the petitioners. Stand over to any urgency.
Of course, my lord, actually in view of the earlier order, petition is to be dismissed.
Take chance, 24th of April.
Please.
Lord, I represent Lord next matter. Lord, I represent the next matter, Lord, 25th.
Number 25.
Lord, I appear, Lord, for petitioners. Lord, I request for a week's accommodation, Lord, some personal inconvenience.
For a week.
Maybe after vacation.
As the petition has become infructuous, my lords. They've been taking time. The only thing is, the
No,
issue
it is not
my
infructuous.
lords have-
I will argue the
my lords
matter.
my lords may recall, there's an issue with regard to a fish cutting unit within the limit of 50 meters of CRZ limits. my
So
lords.
when petition or matter becomes infectious, they appear to be on the week.
Lord, a week's Lord, time, Lord, I am not, it's not infructuous, Lord. May not be correct. A week's time.
I leave it to my lords.
How it is infectious?
So that's
It is
what has
not-
happened is the same petitioner, my lords, where there's a NGT proceedings which is going on. There they have gone and made a submission that we have closed down the unit and we have dismantled all the equipment. Now, my lords,
That
today
is regarding other unit, my lord, not this unit. Let me not confuse the matter, my lord. That is another, there are two units, my lord.
Permit him to make submissions.
Please.
Yes.
That's based on that submission made by the petitioner before the NGT, my lords, where the contempt proceedings is initiated against them. Before NGT, we are making a submission that, my lords, nothing survives here. What we have done is, based on an NGT order, we have revoked their consent. And that is being questioned here before my lords at serial number 25. Along with it, my lords, there are two other PILs and one writ petition, my lords, which is tagged along today. So, my lords, that I think my learned friend is appearing
I
for.
represent the petitioners in the connected matter, my lords. The children, my lords, who study in a school in the adjoining compound. My lords, there were certain other villages, my lords, who had approached the Honorable Greens Tribunal. And my lords, there is already an order, my lords, which I've already placed on record. My lords, on the 19th of April.
This petition is in respect of court prayer.
Revocation of consent.
It is done by you as per the NGT's order.
Yes, my lords. It is pursuant to the NGT orders, which, my lords, my
No, 2 days time,
Everything
Lord.
is
Next week, Lord, I will argue the matter, Lord. Some inconvenience for today for me. Let my friend not take my position, Lord. 2 days time or a week's time, Lord. I will argue the matter. No public agency involved, my Lord, in this matter. Lord, a withdrawal order is passed, my Lord, not according to NGT order. That is on the basis of the fact that, my Lord,
Other
they are
matters
the
listed today. Other matters listed today will go with this.
Yes, Maharaj, it should go because the minute Maharaj, the unit is closed, their grievance is also addressed to
But
a
in
large
fact, I'm
extent.
ready with an affidavit stating.
You are also saying that it is infectious.
I'm sorry.
No,
You are also
it is not
saying that-
infectious, my Lord. I'm sorry, my Lord. It's not infectious. Very sorry,
But
my
so
Lord.
far as my petition goes, so far as my petition goes, the petitioners have prepared an affidavit to state that notwithstanding their undertaking before the honorable tribunal, they are continuing with the procedure, the units, both the units. There are 2 units.
You are a PIL petitioner.
But I'm the petitioner and the PIL. It's a fish cutting unit and
So
fish.
you want the discontinuance of the process in view of the
Yes,
NGT.
that is what we have sought.
First petition is
Then there is
allowed.
already an order of the
Absolutely,
NGT.
there is already an order.
So your PIL will not survive in view of the order of NGT.
Yes.
It will not survive because it is infectious.
That is
The third will not survive because the 2 other will not survive.
Lord, a week's time, my Lord, finally, grant, I will argue the matter, my
Any
Lord.
time my friend wants, Maharaj. Any time he wants.
A week's time, my Lord, I will argue the matter. It's not, sir. It will not be infectious, my Lord. A week's time. I pray, my Lord. Some inconvenience.
Have it after vacation, Maharaj.
No, if
Maharaj,
it is
to have it.
infectious, why before?
It is not infectious, my Lord.
Maharaj,
Definitely
I'll
not
leave it to
infectious.
Maharaj.
My Lord has heard this matter for 1 hour, 2 occasions. My Lord was pleased to hear this matter for 1 hour on last 2 occasions.
That's true.
Matter
1
still
hour after
survives.
we are not convinced.
My Lord is remembering, my Lord.
After 1 hour we are not convinced, then what else?
No, my Lord was about to pass orders, my Lord. It was 5 o'clock at that time.
Come on, 23rd.
It was 5 o'clock at that time.
23rd.
No, 23rd next week. Before 2 days thereafter, my Lord.
2 days after his vacation.
25th, my Lord.
24th.
25th, my Lord. Please, my Lord, argue the matter.
25th at 11.
Very well.
All matters.
One submission.
To be listed in
Please.
separate. To be listed in separate.
One submission.
Please,
Yes,
sir.
sir.
Please,
Number
please.
81, Mira.
81. Please, deeply please.
All matters, give the numbers. It was stated by learned respondent. These petitions are liable to be disposed of as having become infectious or not surviving. In that view, list all matters in a separate board to be taken up at 11 on 25th of.
Please.
Please, Mira.
Yes.
Serial number 81, Mira.
Subject to the contention of the other side.
On submission. Serial number 81. I'm appearing for appellant. It has listed in orders. I have to take steps for R1 and awaiting notice for R4. Lord, I seek date after vacation, my Lord.
After vacation. So notice is not
Interim direction may be extended, my Lord. Interim order.
It will be extended. When shall we keep? 19th of June?
Please, my Lord.
Please. ಒಂದು ಮ್ಯಾಟ್ರ್ ನಾವು ಕ್ಲೋಸ್ ಆಗ್ತೀವಂತ ಅವ್ರು ಬಿಡಲ್ಲ ಹಂಗೆ ಮತ್ತೆ
ಸರ್ ವಿ ಸಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಪೋರ್ಟಲ್ ಒಂದಿಂದ
Sorry, keeping you waiting. Yes, some other
Your Lordships.
engagements further. Yes,
Serial number 72 and 73, Your Lordships.
72 and 73.
Your Lordships, it's a date given matter. It's a mining matter, Your Lordships. As appraised to your Lordships in the previous hearing, the petitioner's all equipment has been seized according to a order from the Madras High Court. The matter may be taken up at least after 2:30 list, Your Lordships.
What is the urgency as such?
Your Lordships, all our equipment have been seized. It's a mining lease. They have indefinitely stopped the mining. We are not able to mine, Your Lordships. It's been almost 1.5 years that the mining has been stopped.
If it doesn't reach today, we'll take up on some other day.
Your Lordships, at least at 2:30, if it may be fixed in
Today
the.
we don't know, some matter is parted, matter is going on already.
Even if a short date, at 2:30, it may be fixed.
We'll
Your
see,
Lordships.
we'll see at
Much
the end of
obliged.
the day.
Much obliged.
Serial number 39, my lord.
39.
Respondent bank also preferred appeal 390 of 2025. Both the matters may be taken together during next week. Respondent bank also preferred appeal 390 of 25. Both the matters may be taken together during next week.
It was submitted that cross appeal number
393.
after vacation.
Next week.
Next week
We'll
no
take
time.
chance.
25th of April.
Much.
Your Lordship's kind leave. Serial number 97, my lords. 97, serial number 97. Lordship may kindly grant me 2 weeks' time to comply with the office objections.
97.
Yes,
After vacation.
after vacation.
26th of June.
Much obliged.
Except this. This may be taken on. Oh, this may be taken on 345. बाकी के लिए
Serial number 105, so withdrawal of contempt. Mr. Lokesh KV.
memo dated 19 to 25. Figures on record in which Loner complainant seeks permission to withdraw the present petition. To stop in view of the said memo, permission is granted, the petition is withdrawn. Permission is granted to withdraw the petition. The petition.
Serial number 106, Mr. A. Madhusudan Rao.
With copy for the petitioner, please. Statement of objections are to be filed by the other side.
Why it is kept at 2:30?
Have not been served with the statement of objection.
2 months salary.
2 months salary had to be paid.
Government will pay the, where is it in open house?
There is no government.
There is no complaint.
Government is not a party. Government is not a party in the original petition at least.
Error number 3, CR.
Hmm?
In compliance of that, stated in.
Error number
3.
3.
My predecessor had issued necessary order fixing the date of retirement of the complainant as 31/5/2018 and to grant all consequential benefits thereon.
Here you are reading.
Para number 3, madam. Para number 3, compliance of that.
We don't have any complaint. Read it. I state that my predecessor same.
Complainant has 31/5/2018 and to to grant all consequential benefits thereof. Subsequently, all benefits were paid to the complainant except the salary for the month of April and May 2018 is due. Since the salary and other obligations are being made through HRMS Human Resource Management System portal by the state government directly to the employees of the university.
So you are paid, they are saying. They are paid?
They are going to pay me.
They are paid?
They are going to pay me.
This is by whom? By you. You are for university.
State government will pay.
You are for university.
Yes, ma'am.
So which paragraph you are reading?
Para number 3, ma'am.
Paragraph number 4. Paragraph 4. Read paragraph 4. University has taken all steps and has made accordingly made the payment. So you also made some payment? Don't know what you have written. They are simply disputing, Mr. Ah. So the affidavit is not. Where is the direction?
Direction is at in. In page number 13. Para 10, my lord. In the light of these facts, in my view, the university would be bound to consider the petitioner's date of birth as 27/5/1998, and consequently, the petitioner would stand retired on 31/5/2018 and not on 31/3/2018. As a consequence,
any calculation is there about your salary? What is the amount payable?
2 months salary. I'm not sure. I'm not sure about the amount. I'm not sure about.
You are also not sure. So yes, when you are going to pay?
2 weeks.
No. You have to pay by 16th of this month. Bring the check here. Either you bring the check or you bring the registrar of your university. Choice is yours. What you will bring? You will bring check or you will bring the registrar? Registrar. No. You are highly inconsistent, highly unreliable, highly misdirected in your affidavit and your submission. And the government was never a party in any proceedings.
There is a scheme in university. Human Resource Management System. They will directly paying the.
You recover from them if you are entitled to recover from the human resource department. But first you have to pay. That is the direction.
We will going to pay.
Going to pay when?
In 2 weeks.
No, single as well as seen the affidavit filed by the university, which is apparently inconsistent, passing the buck on the state government regarding payment of salary and other consequential benefits as directed to be paid by a single judge. Petitioner asserts undisputably that no amount is paid so far. Paragraph. Learned advocate, kindly listen, thereafter give cheat. In the middle of the proceedings, you don't pass the cheat. Listen the order. Learned advocate, Mr. So-and-so states that amount comprising of the salary for 2 months and consequential benefits, if any, as directed by learned single judge in his order dated 29th November 2023 shall be paid to the petitioner on or before 16th of April. Full stop. In any view, it is directed that the respondent university shall bring the check in the name of the petitioner towards the benefits as above in compliance with the directions of learned single judge on the next date of posting. which will be 16th of April 2025. If the amount is not paid before the said date or the check is not brought to be handed over to the petitioner before on or before that date, comma, respondent number 1, who is whom you joined?
Shailaja, the registrar.
Respondent number 1 shall remain personally present on 16th at 2:30 before the court to answer as to why the proceedings of contempt for non-compliance of the
Number 107. Srimati Maitreyi Krishnan.
Before the petitioner, my lord. My lords, on 1st January 2022, a compliance affidavit was filed by the state.
correct
31st January 2022, my lords.
22.
Yes, please. It is as per the order dated 9th July 2021. My lords has that compliance affidavit.
One to 22.
31/1/22, my lord. That is the
My lord,
date.
it's 1st of February
1st of
2022.
February, yes.
Please. It is verified on 31st January.
This should satisfy you.
Please, my lord, if my lord would just see para 5, if they are just directed to do it in a time frame, my lord, because after that, it's still not been done. Para 5 says that the executive officer is taking further steps in the matter to complete the process.
So new layout is being formed.
Yes, my lord, yes.
New layout is
And they
being
are to build the houses for the
For this-
residents.
this community or class, whosoever.
For this group, my lord.
My lord, for
They
the
have- they-
families, 122
Displaced persons, please, my lords.
structures now, but there's an impleading application that has been filed to contend that, my lord, this area that has been allotted for, my lord, for rehabilitation belongs to the impleading applicant.
I appear for impeding applicant in this case.
My lord,
If
in
he
the-
was the owner, he would have been in possession of that extent.
Order is passed by you.
My lord, under section 64A, along with our statement of objections on 8/2/2021, my lord, we have produced the order copy where we have directed eviction of all these 122 families who were, my lord, who had encroached upon the forest area. Thereafter, my lord, for rehabilitation, the government has provided 2.10 acre, 2.10 acres, my lord, and the executive officer, Taluk Panchayat, was supposed to take it forward because we have handed over possession of the land to him. We are nearly 3 years away, my lord, from 22.
The executive officer, my lord, is respondent number 11.
Permitted to
8/2/22.
1/2/2022, we filed the affidavit.
No, that this eviction order.
My
Eviction
lord,
order
eviction took
is-
place in 2015 itself, my lord.
My lord,
Eviction had
it's,
taken place previously. Subsequently, my lord, a decision had been taken to rehabilitate these persons.
My lord, it's 16/1/2007, annexure R1 along with the
16/1,
16/1/2007.
2007.
Yes,
Eviction.
yes.
And there is-
Thereafter, my lord, we have provided rehabilitation for these 122 families.
We can say expeditiously they will
I'm sorry,
take
my lord,
this.
my only request is this, my lord. 22 in January 2022, villages, Weavers Colony. Any time frame may be given, my lord. That is my only request in this process.
My lord, it's 3 years.
Latif, I am permitted to raise the
You are number 11?
as impeding applicant to
11.
Respondent number 11 is the
Has served
executive officer, my lord.
unrepresented.
No.
Executive officer is respondent number 11.
Served and unrepresented.
We were directed to make them a party. We have made them a party.
And who is the impleading person?
My lord, he claims to be the owner now.
Owner of the property, present permitted to the order passed by the AC and present title is standing in my name.
My lord, the total property is around 34 acres, my lord.
On what basis you are claiming ownership?
I'm the grantee of the land from my forefathers. I'm permitted to produce the copy of RTC and section register and AC order.
So you are in possession.
I mean,
How do you say that?
constructive possession order. They are not all. That has
Keep it with you. How do you say that you are?
that has
Keep it with you. How do you say that you are in possession? How do you say that you are in possession? On what basis?
the document stands in my RTC is in my name. I will not speak. AC has passed the order in my
So where is your order granted?
My lord, may I just clarify this
My lord,
point, my lord?
ours is affidavit filed on
The survey
1/2/20.
number, my lord, has a total of 34 acres, 38 guntas. Out of 34 acres, 38 guntas, my lord, the impleading applicant says that they are owners of 4 acres, 11 guntas. 2 acres, 10 guntas has been granted insofar as the petition is also only saying that they are the owners of 4 acres, 11 guntas. So it does not have to do with the 2 acres, 10 guntas, my lord.
So you earmark the boundaries of your allotment and.
Please, my lord.
My lord, he has
That
to
has
do
been
it
done.
in accordance with law. I cannot take on the responsibility of demarcating his 4 acres.
Identify what you have allotted for the rehabilitation purpose. That you can identify.
My lord, it has been identified and it has
It's
been handed over
identified,
to the
handed
executive
over,
officer.
My lord, annexure R1, my lord may take it along with my compliance affidavit, my lord, page 7.
Compliance affidavit, same
Same one.
1/2/2022.
Same affidavit.
7. 20th September 2021.
20th September.
Yes. No, my affidavit is 1/2/2021, my lord. In that annexure R1 I have produced.
1/2/22, my lord. The same one that my lord was referring to. Annexure R1 has the document handing over the prop.
My lord gets it, land handing over letter.
Boundaries have been identified.
Yes, ma'am.
And the Chekka Bandi have been fixed.
Yes.
What more do you want? If you have any claim, you will keep your drive open. If at all you are claiming this land, you can file independent process. Pass.
Application.
So what order you are producing?
AC order passed by the AC to reflect my name in RTC. Accordingly, RTC stands in my name 2020-24 and MR also produced your lordship for
You are claiming how much? 4 acres and 11 acres.
4 acres,
4
11
acre 11 guntas.
Your IA is? IA number?
IA 1
1
of
of
25.
2025, my lord.
So will not serve, I will say this. And I will say expeditiously they will take steps.
My lord may only consider giving some time frame so that it has already been 3 years. It is for housing, my lord may consider giving any time frame.
We will not like to bind them in that way. Expeditiously within 1 year.
Please, my lords. At
My
least
Lord, I'll
some time frame, my lord,
communicate to the
that at least.
executive-
Within 1 year. 1 year.
My lord, I'll communicate to the executive officer, town panchayat.
Preferably within 1 year.
My lord, as soon as possible, my lord, because it's a question
There
of
we
housing.
can't, there are a lot of technical things you know. This.
My lord, in
Because
fact,
land
they
has
should
been
have
handed over
notice of
for
my
the last
lord
2
with
years, they
regard
have
to
not
the
done anything.
improvements,
That's the
my
only
lord.
reason.
They should have brought to the notice of my lords, what has happened to that 2.10 acres. The very fact that there's no information, my lord, belies their contention. If they had said there's nothing happening, my lord, then my lord could have directed us.
Evidence like
ಸ್ಲಿಪ್ ಬರ್ಕೊಡಿ ಅಪಿಯರೆನ್ಸ್
Most grateful.
We'll pass the order.
Obliged.
We'll reserve liberty for you to institute the challenge in your, as far as your part is.
Yes, sir.
This disposal will not come in your way.
Yes.
And within 1 year, my lords, within a outer limit of 1 year, my lords. may
What?
direct.
That was.
Most grateful.
ಇಲ್ಲ 108 ಇವ್ರು ಯಾರೋ ನಿಂತಿದ್ರಲ್ಲ ಏನಿದ್ರೆ
ನಾನಿಲ್ಲ ಅದ್ರಲ್ಲಿ ನಾನಿಲ್ಲ ನಾನಿಲ್ಲ ಸರ್ ಅದ್ರಲ್ಲಿ ನಾನಿಲ್ಲ ಅದ್ರಲ್ಲಿ
Only 17th I'm not in town, any other date. Sir.
18th, your lordship.
Or after.
Any day convenient to the court.
My lord.
I understand the pressure on your lordship, but in all fairness, possibly after vacation.
My lord, I have just a small submission. I have a very, yes, my lord. I just want my application to be approved, my lord. I filed my application for party in person and as a respondent as well, as an impleading applicant, my lord.
Who are you? One of the owner of the flat.
I am an apartment owner as defined under the statute.
Granted. Others are granted. Her is also granted.
Thank you so much.
Which is your application?
IA 9 of 21.
9 of 20.
Yes, my lord. And listed on a point number 3. Purnima Praveen Sali.
So IA
9 of 21.
21. 21.
Yes, ma'am.
We'll grant that IA today.
Yes, ma'am.
2, 3 and 4 also. 2, 3 and 4 IA, my lord.
That is granted, 2, 3.
Many of the
No, my lord.
impeding
It
ones,
was
are-
not come in the order, so I couldn't file the.
Lord, many of them are supporting us also. So
It is
we have no
granted.
problem if all are allowed.
3. It is already granted, available on the website.
Cautious will recollect the conditional order.
That is being granted today. Oh. She has not gone or not denied the certificate.
Yes, yes. My party in person has been approved, my lord. My application for pleading has been. My party in person.
You got that certificate from the committee?
Yes, my lord. Form C was issued last year, October 2024.
Yes, well. So today that is granted. Rest of the, it is already granted. Your IA 3 for
2, 3 and 4 of 2024.
3 is granted, 2 is granted, 4 is granted.
2, 3 and 4 of 2024.
Already granted. We don't know.
May be permitted, my lord.
Today we know about only part in persons IA 9 of 21, which is granted.
Thank you, my lord. Much obliged.
That is granted. So rest of matter will be, when shall we keep? 20,
When the court is.
28th.
My lord.
Before vacation itself, kindly be before vacation. Your
28th is before vacation.
Before vacation.
Yes.
This is before vacation. 28. This was argued and
For some time.
the difficulty that at least I forget once. 28. Please. And the
Thank you,
IA
ma'am.
is granted.
Thank you, my lord.
Great.
Much obliged.
Well, it's 28. Is it at 2:30 or in the regular list?
2:30 maybe.
Any
2:30.
My lord, my only submission is please allow me some time to make a substantial presentation. Thank you, my lord.
Cell number 104. Cell number 104.
The appellants in this case, my lords. Represent the appellants. We have concluded arguments in this matter for the respondents to commence their argument.
ಇನ್ನೊಂದು ಸಿನಾಪ್ಸಿಸ್ ಶಾರ್ಟ್ ನೋಷನ್ ಮೇ ಕಮಿನ್ ಸರ್ ಇದೊಂದು ಸಿನಾಪ್ಸಿಸ್ ನೋಟ್ಸ್ ಕೊಡ್ತೀನಿ ಆಯ್ತು ಆಯ್ತು ಕೆಂಪರಾಜು ಸರ್ ಕೆಂಪಯ್ಯ ಸರ್ ಕೆಂಪರಾಜು May I commence, Your Lordship? Before I commence, a bird's view of how the Abolition Act came into force. Your Lordships may kindly see, prior to independence, the province were ruled by the king. All the properties in the kingdom vested with the king. In order to seize, he could not have employed a series of employees, so he used to give employees certain people. You see that the crafts and artists and different, he used to give lands by way of, means with no strings attached. Your Lordship must kindly see the operation. In the definition, section 1 says what types of people are there to be now. Short, I mean, I will not take your Lordship to. Your Lordship may take it to section 1 of the book. There, various types of enums are specified. This applies to personal enums. I am Gupta, Village, Kodagi, Banwadi, Devsanam enums, miscellaneous services. Your Lordship has been ticketed. Then your Lordship, because they were not paid salaries. So it is that view of that the lands were granted to them by way of a gift to those people to sustain them and to see their professions. And the enum did not attach any strings to that. They could have very next day after the enum, they could have mortgaged it, they could have leased it, they could have sold it. But the enum made them absolute owners on the day when it was vested. Then after the independence, in order to, because certain various transactions had taken place between the enumdars and the tenants and all, in order to see that the entire thing, the Enum Abolition Act came. The enum, after the Enum Abolition Act came into force, the state took over the charge of the enums, and only for the purpose of redistribution among the person who had a right in the property. The persons who had a right in the property was categorized broadly into two: tenants and the enumdars. Subclass of tenants are Kadim tenant, Kayam, we will not go into that. So the objective of the Enum Abolition Act is to regularize the earlier enums which are made and who have succeeded to this. That's all. So why I am trying to say this is that an attempt was made by the other side to say that the Enum Abolition Act and the Land Acquisition Act have imparinity here. So the vesting in the Land Acquisition Act has to be construed, and the same meaning. So the vesting in the Land Acquisition Act has to be construed, and the same meaning has to be given to the vesting appearing in the Enum Abolition Act also. I would like to say that the Enum Abolition Act and the Land Acquisition Act have no parallels at all, have no comparison at all, and no similarities. For the reason your Lordship may kindly see, broadly, the Land Acquisition Act contemplates several stages. One, the preliminary notification. The preliminary notification should mention the area, extent of the land to be acquired, the owner's name, and the purpose for which it is to be acquired. These are the essential ingredients to the preliminary notification. As soon as the preliminary notification is issued, there is an embargo, statutory embargo on the people. After the issue of the notification, 6 award has to be passed. Then possession has to be taken. It's only thereafter the property rests with the government. Non-compliance of any of these provisions, not completing, not making a final notification within 2 years, not making an award, not taking possession, makes the entire acquisition void. So, and your Lordship and see in the Acquisition Act, the beneficiaries are the strangers, unknown people. Here the beneficiaries are the persons who had a right prior to that. Under the Land Acquisition Act, the land never reverts back to the owners. And the essential, one more essential ingredient of the Constitution. One more essential ingredient of the Land Acquisition Act, it is mandated that the compensation should be paid at the market value. Otherwise, the entire act will become general. So, Lordship, see Article 31A of the Constitution, second proviso. Second proviso is the mandatory. Article 31A, saving laws provided for acquisition of the estates, etc. And your Lordship kindly see the Article 31A. second provision. I'll be very brief. Provided further, second provision to Article 31A, provided further that there any law makes any provision for acquisition by the state of any estate and wherein the land comprised therein held by a person under his personal cultivation, it shall not be lawful for the state to acquire any portion of such land as is within the ceiling limit applicable to him under the law for the time being in force, or any building or structure standing there or appartment thereto, unless this is the next your lordship may kindly see. Under the Land Acquisition Act, the owner is divested of his land. Possession is under the Abolition Act, possession is never taken. So now the next point is your lordship Jodi Inam. Jodi Inam is a land which is uncultivable, inhabited, and situated far away from cities. This particular land, Chalamanapunte, your lordship may kindly subject matter, about 494 acres of land, was situated 40 kilometers from Bangalore. At that time, there was no communication, no roads. So it was, and they had no resources, water resources for cultivation. As such, the land was never tenanted at all. The value of those lands were very meager. As your lordship says, the
1943 KP Ramaya.
KP Ramaya sold the entire 494 acres of land in favor of Kaveri Reddy for a total consideration of 5,000. 1,000. So these lands were given to certain people with an intention they make it habitable or make it cultivable. It was given free. Now, the point that arises for consideration is whether the persons who have made an application. Now, your lordship may kindly say, I'll pass on the dates and events, which the one which is furnished by Null and Margaret was little inaccurate. The series of events that has taken overall consideration of this 5% in repetitions on so. Then on 28/9/48, oral partition is appears to have taken between Kaveri Reddy and his two brothers, and which the Kaveri Reddy gets 160 acres of land, and the other two brothers get it equally. Then the Kaveri Reddy, there is a recital, there is a mention in that the Kaveri that is page number 151. Muni Bhairappa's name is substituted by Rodaya some places. That's why the confusion arises, because the mortgage was bad, and then I'll come to that later. But your lordship may kindly see that mortgage was never enforced by any person. Muni Bhairappa did not enforce the mortgage, that was not the subject matter. It is on 10/3/53, your lordship may kindly see, one Dodaya files a suit for recovery on vesting the subject lands in the